To the Explainer. Today, we're diving into some seriously high-stakes corporate drama to test something pretty incredible. Can AI actually think like a federal judge? We're putting artificial intelligence to the ultimate test in the highly complex world of antitrust law. We're going to unpack a totally fascinating experiment applying AI to the multi-billion-dollar handbag wars between two massive fashion conglomerates, Tapestry and Capri. We want to see if a language model, using just standard economic principles, can spot the exact same strengths and weaknesses in expert testimony as a highly experienced human court. So here's our roadmap for this explainer. We'll start with the handbag merger drama, then define the Goldilocks market. After that, we'll run the AI antitrust experiment, look at the strengths and weaknesses the AI found, reveal the final AI versus judge scorecard, and wrap up with why this matters for all of us. Let's get into it. Section 1, the handbag merger drama. Let's start right at the beginning with the proposed mega merger that kicked off this whole legal showdown. Picture this. It's August 2023. Tapestry, the company behind iconic brands like Coach and Kate Spade, announces they're going to buy Capri, the owner of Michael Kors. The price tag for this deal? A massive $8.5 billion. This wasn't just your run-of-the-mill corporate acquisition. It was a major play to consolidate a huge chunk of the fashion retail space all under one roof. But man, those dominoes fell fast. The FTC swooped in to stop the deal in April 2024, which led to a super intense 7-day evidentiary hearing in September. Fast forward to October 24th, and a district court judge issued a sweeping 169-page opinion granting the FTC's preliminary injunction, which effectively blocked the merger. By mid-November, the companies completely dropped the deal. So why exactly did the government block it? That brings us to Section 2, defining the Goldilocks market, because this entire antitrust case really hinged on one massive, central question. How exactly do we define the market that these bags compete in? The battle lines were firmly drawn. The FTC argued that Coach, Kate Spade, and Michael Kors all sit in a highly specific, accessible luxury market. It's the Goldilocks zone, right? They aren't too cheap like mass market bags, but they aren't ultra expensive like those high-end European fashion houses either. The defense, on the other hand, pushed back hard. They argued this was completely artificial and claimed they compete with literally all handbags and all luxury goods everywhere. And those two very different definitions, well, they completely change the antitrust math. If the market is just accessible luxury, like the FTC claimed, combining these three brands creates a near monopoly with about a 58 to 59% market share. Huge red flag, right? But if the market includes every single handbag ever made, like the defense claimed, this $8.5 billion merger barely makes a dent in competition. So how do economists actually solve a puzzle like this? Well, the FTC's expert used something called the hypothetical monopolist test, or HMT. It asks a beautifully simple question. If one single company owned Coach, Kate Spade, and Michael Kors, and they suddenly raised prices by just 5 to 10%, what would shoppers do? Would enough shoppers just say, forget it, and switch to a much cheaper mass market bag, or maybe splurge on an ultra luxury bag, making that price hike unprofitable? Or would they just eat the cost? Let's break down the math real quick. Using a typical 60% gross margin for these types of bags, the expert determined the critical loss point was just 7.7%. Basically, that meant they needed an aggregate diversion ratio higher than 17% for the FTC's narrow market definition to be proven correct. And when they looked at actual consumer surveys, the diversion ratio, which is the percentage of customers who would just switch to another brand within that same group if prices went up, was well above that 17% mark. The test passed by a mile. Section 3, the AI antitrust experiment. We've got a highly technical economic argument filled with diversion ratios and margin math. The million-dollar question is, could an AI actually understand and critique it? Here is the 4-step methodology we used to test AI as a first-pass interrogator of expert economic reports. Step 1, we start with the publicly available expert report. Step 2, we ask the AI to generate a critique based purely on standard antitrust economics. Step 3, we look at the actual court decision. And finally, Step 4, we test the alignment. Did the AI spot the exact same issues the human judge did? Section 4, AI identifies strengths and weaknesses. Using only publicly available summaries and standard principles, meaning absolutely zero access to sealed exhibits or raw data, the AI model went to work finding the pressure points. Right out of the gate, the AI nailed several key strengths in the FTC's approach. It correctly noted that using actual survey data to see who consumers switch to if prices go up is a super strong standard practice for differentiated consumer goods. It also praised the FTC for combining the math of the HTMT with the practical realities of brand positioning, instead of just relying on those historically flawed, simple price correlation studies. But here's the real kicker. The AI also flagged some major vulnerabilities that the defense could totally exploit. It warned about survey hypothetical bias, which is basically the very real risk that what people say they'll do on a survey isn't what they'll actually do when their hard-earned money is on the line. The AI also flagged potential selection bias in how wholesale versus retail data was weighted, and even questioned the assumption that profit margins would remain completely constant after a massive merger. Section 5. The AI versus Judge Scorecard. The moment of truth. Let's see how this independent, public data-only AI critique stacked up against a real, human judge who had full access to all the sealed evidence and live testimony. First up, on the core issue of market definition, the judge agreed entirely with the FTC. The court officially accepted that narrow, Goldilocks accessible luxury market and completely threw out the defense's broad all handbags argument. The FTC's expert analysis, which, remember, the AI correctly noted was built on a solid framework, completely held up in court. But what about that survey hypothetical bias the AI so smartly warned us about? Well, the court cared deeply about that too. The judge found that internal, ordinary course business documents from the companies themselves completely validated the surveys. It turns out the companies constantly monitored each other's prices, specifically within this accessible luxury segment. That real-world behavior proved to the judge that those high diversion ratios were totally real, not just a quirk of the survey. When we tally up the final scorecard, the alignment is just mind-blowing. The AI independently identified the exact same fundamental economic principles and methodological pressure points the court ultimately cared about. The AI flagged survey bias. The judge scrutinized it and resolved it using internal documents. The AI questioned data selection. The court evaluated it. The AI performed remarkably well at spotting the precise questions that needed answering. Which brings us to Section 6, Why This Experiment Matters. What should you, the focused learner, take away from this high-tech legal experiment? Why is it such a big deal that an AI can read a handbag merger report and essentially think like a federal judge? The absolute biggest takeaway is that AI is a remarkably effective, rapid, structured, first-pass interrogator of expert economic reasoning. Now, AI doesn't replace deep legal knowledge, and it certainly doesn't predict final court outcomes, since it can't see private evidence. But it can save legal practitioners a massive amount of time. It acts as an incredible sounding board, instantly finding the exact assumptions and data gaps that demand closer human scrutiny. So, we leave you with the question that kicked this all off. Could AI provide substantive critiques of economic arguments in significant antitrust cases? Looking at the stunning alignment in this explainer, the answer is a resounding yes. We're looking at an incredibly powerful new tool for evaluating complex litigation. As AI gets even smarter, will the lawyers of tomorrow spend their time hunting for the needle in the haystack, or will they just ask the AI to burn down the hay?
Thanks for watching. For the deep dive economic analysis behind these stories, join us at econworks.com. Subscribe to stay informed on where law and economics meet the market. We'll see you in the next episode.